There is no doubt that the landlord and tenant laws in Ontario are tenant-friendly. For this reason, it is very important that a residential landlord be very familiar with all the legal technicalities prior to filing an application at the Landlord and Tenant Board. For example, if your tenant owes you rent, you will first need to complete and serve your tenant with a document known as an N4 notice. At that point, your tenant will have 14 days to pay his rent. It is not until after this 14-day period that you will be able to file an L1 application requesting an eviction order and an order requiring the tenant to pay the rent owing. However, if your tenant moves out during this 14-day period, you will no longer be able to bring an L1 application, and you must instead commence proceedings at the small claims court. Furthermore, your tenant can respond to your L1 application by raising maintenance issues for the very first time on the day of the hearing without having given you any prior notice. At that point, you will have two options. First, you can try and defend the maintenance application without having had any time to prepare, or you can request an adjournment, thereby allowing your tenant to get away without paying even more rent. Moreover, an experienced and unethical tenant can get away without paying his rent for many months or even years. And the current measures in place because of COVID-19 has made this a lot easier for these dishonest tenants. Right now, in some cities in Ontario, an eviction order cannot be enforced regardless of how much money a tenant may owe you. But we are here to help. Please call us at Harry Searles Professional Corporation for a free consultation where we can try and map out a strategy for you and hopefully minimize the losses which you might otherwise experience.